Because of this, you should spend the rest of the days locked up to think about what you have done to Jennifer and her family.
We will go on the record in the matter 22 CF 184, State of Wisconsin versus Richard Thone. Appearances are, we do have appearing in person, the state through District Attorney Kevin Schmidt. We have Mr. Thone in person in custody with counsel Lance Nelson. We're set today in this matter for the sentencing portion of the case. Mr. Thone pled guilty to count 1, homicide by intoxicated use of a vehicle as a second and subsequent offense on May 19th, 2025. The court ordered a pre-sentence investigation report. I have reviewed that report and nothing stood out to the court with the facts known to the court as a material incorrect information or statement. We are in victims' rights compliance. We have victims in the courtroom. We have victims who are appearing by video who would be making a statement. Ms. Bauer, outside of the 2 by video who will be making a statement, are there any of the other 3 people here? I'm seeing 2 probably. Just one? All right, okay. So before we start with the statements, I'm going to ask Mr. Schmidt, have you received and reviewed the PSI report?
I have. I've reviewed it. I have no corrections.
All right, Mr. Nelson, have you received and reviewed that report?
I did receive and review it, Your Honor. I also went over that with Mr. Thone. I have no additional corrections or comments to be made at this time.
All right, and Mr. Thone, I'm just going to ask you to let me know if that's accurate. Did your attorney go over that document with you?
Yes, he did.
And did you notice any error or anything that would need to be corrected?
No.
Okay, thank you. All right, before we begin with the sentencing portion of this case, I am going to ask for the victims to make statements, please. I'm going to start with the individuals who are appearing by video, by Zoom. I will ask Samantha to provide her statement first. Samantha, you are not, you do not have your video working, just your audio, and that's A-okay with the court. But if you would like to have your video seen, please hit the video button and then you may start your statement. But first, either state your full name for the record or your initials, okay?
Okay. I am Samantha Kopinski Smith.
May you please spell Kopinski?
Yeah, absolutely. Kopinski.
Thank you. And is it hyphen Smith?
Yep.
All right. Thank you so much. You may continue.
Your Honor, my name is Samantha Kopinski Smith, and I am here because my mother, Jennifer Kopinski, was killed in this crash. My mom was one of the kindest, sweetest people I've ever known. About a year or so before her death, she surprised us all by moving back up to Wisconsin. She was so happy and optimistic when she came back, ready to reconnect with family and friends, start fresh, and be close with me and her grandchildren again. It felt like a new chapter for her, for all of us. She was just starting to really get close with her grandkids, to be a part of birthdays, holidays, and everyday lives. I was only beginning to see her really step into that role of grandma. She loved every second of it. We were finally getting to enjoy life with her again, and then I woke up one morning and she was just gone. The shock of losing her so suddenly and in the manner that it happened has left a hole in my heart that will never heal. She must have been so afraid, probably thinking of me and my boys. I know I would be thinking of my children. It is hard for me to understand how someone can be so careless with something they claim to love so much. Her death was completely preventable. There is no reason that she shouldn't be here right now. And the choices that have caused it have left a lasting impact that no sentence can erase. We feel this loss every single day, and our family will never be the same. I am asking the court to hold Mr. Thone fully accountable. I support the PSI recommendation of 16 to 18 years, and I believe a strong sentence is necessary to reflect the seriousness of taking a life. Nothing will bring her back, but I hope this sentence sends the message that reckless decisions have devastating consequences and that justice must be served. Thank you for your time, Your Honor.
Thank you, Ms. Kopinski-Smith. I am now going to ask Jessica Glosky, and it's spelled Glosky. Is that correct, Ms. Glosky?
Yes.
I am now going to ask you to present your statement to the court.
First off, to Rick, your careless actions, the drinking, the reckless behavior has resulted in a major loss for our family. You have taken Jennifer away from us in a horrible, unspeakable way. I wish she would have left when she had the chance. 2 little boys are now without their grandma, and to have told them that she's never coming back was the most heartbreaking. One would think after a very similar UTV accident 4 months earlier, you would have had a wake-up call to stop drinking. You almost killed her then. When you love and care for someone, you do all you can to protect them. With your actions in just a couple of years, you have proven you never really cared. I believe you should be held accountable for your actions to the fullest. You need to take responsibility for what you have done. Judge, I ask you to please give the maximum sentence. I do not feel Rick should get out with his impulsive behavior. He'll just continue his recklessness. Please do not let him risk someone else's life. He has proven that he cannot be trusted to repeat again. Thank you.
Ms. Glosky, what is your relationship with the victim?
Her niece.
All right, okay, thank you so much. All right, Ms. Bauer, may we have the other individual, please? And they can come and have a seat over there at the black desk. And please either state your name for the record, or you can state your initials. And I didn't want to interrupt Samantha or Jessica during their statements, but if you're going to read something, please read it slowly, so that not only can we all understand it, but so the reporter can take it down.
Okay, my name is Janet Klopinski. I am Jennifer's sister. It's gonna be hard.
And I understand that this is very emotional. So please, if you need to stop and take a breath and to calm yourself, you may do so. We are not in any rush here today. This is our main focus. And there are Kleenexes right there. But again, take your time.
I don't know if I can do it.
Ms. Bauer can read it for you if you would like her to do that.
Gonna have to. I can't. I mean, it's pretty similar, but I'm sorry, I just can't.
There's no apology necessary. This is very emotional.
You have to do the phone and I'll just read what's on the phone. Rick, because of your reckless behavior in August 2024, you took my sister Jennifer from us. You took Samantha's mother, Max, and Alistair's grandmother. You took an aunt, a cousin, and a special friend to so many. It wasn't the first time you caused harm to Jennifer. The accident in May left Jennifer with serious injuries. You would have thought you would have had straightened up and stopped your recklessness behavior, but you didn't. Because of this, you should spend the rest of the days locked up to think about what you have done to Jennifer and her family. I miss Jennifer every day. Because of you, I will never see her again. Judge, please sentence Rick to the maximum sentence. He has been reckless with his life. He shouldn't have the ability to destroy another family. Sincerely, Janet.
Thank you so much. All right, you may go return to the gallery. Mr. Schmidt, I'm now going to turn to you for the state's argument and recommendation.
Thank you. My recommendation is going to be a 17.5 year recommendation broken up into 7.5 years initial confinement, 10 years extended supervision. So that's a little bit lower than the PSI in the initial confinement, a little bit longer on the extended supervision. The general purposes I think the court should weigh heavily on this one would be incapacitation and protection of the public, as well as general deterrence and punishment. I'm going to talk a bit about specific deterrence and rehabilitation on this because there's things to be said about it, but I think they take a backseat on this one due to certain content in the PSI. I think that my recommendation is necessary to not depreciate the gravity of the offense or the loss suffered by the community and the family of the victim. There's really only one place I can possibly start in this argument, and it's with this. Richard Thone killed Jennifer Kopinski. She was his fiancée. They had been together for a substantial period of time. From review of this case, as well as my review of other cases, including Barron and Douglas, they obviously loved each other deeply. His remorse at what he's done is genuine to his benefit. He has obviously both inflicted and suffered a great loss because of his actions. I don't think anyone could legitimately disagree with that. I state those things to make the general point, not just with Mr. Thone, not just with the family, that in this case, a great loss has occurred. And as a result, this is a high severity offense. This is a high gravity offense and prison is necessary. That's why the legislature made this offense have a statutory minimum of 5 years initial confinement, which to compare, 5 years is higher than the statutory minimum of OWI 10 or 20 or 50. Legislature thinks when someone dies as a result of an OWI, it is more serious than the most serious OWI offense. So this is a prison case. Mr. Thone could be sentenced to up to 25 years initial confinement, up to 15 years extended supervision. DOC recommends 9 to 10 in, 7 to 8 out. Mine's a bit different. So I'm going to describe what I think are the aggravating and the mitigating factors. The loss to Mr. Thone is the main mitigating factor. There's another one I'll allude to in a bit. This is an offense that involves alcohol, driving, and harm done to Jennifer Kopinski. And what's disturbing about that is when you look at Mr. Thone's history, you see a pattern of those three things, not just in terms of physical injury, but other impact as well, other negative influence. So I'm going to touch on something that I think one of the victims mentioned because I think it's an important theme of this case. One, that this death was both imminently predictable and imminently preventable by Mr. Thone. Second thing I want to point out is that the history demonstrates this and demonstrates Mr. Thone's lack of ability to change his behavior to prevent this predictable death, despite his professed love for the victim and his professed remorse for her death. He seemed to drag her down with him in his own apparent despair about his own health conditions. Part of that is obvious from the PSI. The agent hit on it, and I've talked about it at past hearings in this case. 4 months before this event happened, a similar event happened in Barron County. Richard Thone rolled a black Yamaha UTV or ATV in Barron County and BT'd there above 0.08. Both he and Jennifer were injured. That is, she was with him at that one as well. What we didn't know prior to the PSI is that when Mr. Thone was interviewed by DOC, because he was still on probation at the time that happened in Barron, he himself had recognized that they were lucky to be alive, and he claimed he would never drink again. He claimed that he had been impacted by that case and the potential threat to their lives by the danger of this ATV rollover while he had been consuming alcohol, and he wouldn't drink again. 4 months later, he did drink again, he did drive again, Ms. Kopinski is with him again, and driving really the same type of vehicle, a new black Yamaha ATV. He bought a similar one to the one he had rolled previously. And it crashed, and Ms. Kopinski was not lucky this time, like she was the first time. Mr. Thone agrees in the PSI that he was intoxicated, but he also seems to complain that there was also something wrong with the trail in some manner. So he is accepting responsibility, which is a positive. It is disheartening that Mr. Thone would do the exact same thing 4 months later. That nearly dying and nearly killing Ms. Kopinski 4 months earlier did not actually change his behavior. That alone did not have a specific deterrent effect on Mr. Thone. The consequences to himself, injuring himself, to injuring her, to nearly killing both of them, to DOC's actions in response, that was not sufficient for him to specifically deter his behavior for even 4 months. That is not the only injury that Ms. Kopinski has been exposed to by Mr. Thone. To elaborate a bit more on that, I think it would be helpful for the court to have some more information about that DC obstruction that occurred in Douglas County that's mentioned in the past history in the PSI. According to the police reports in that past Douglas case, a Douglas County deputy had a call that people were alleging that Mr. Thone and Ms. Kopinski were being disorderly at a tavern. On the way there, he happened to see their vehicle passing. He shined a spotlight on the driver's side and affirmatively saw a male driver and an unknown passenger. So he hung a U-turn, pulled the vehicle over. He could visually see as he was approaching, he could see the driver moving into the back seat and the passenger moving into the driver's seat. When he approached the vehicle, it was Ms. Kopinski who was sitting in the driver's seat and Mr. Thone sitting in the back. They claimed that she was driving the whole time and that Mr. Thone hadn't drank at all, another thing that was proven false later with subsequent tests. As a result, Mr. Thone was convicted of that obstruction for lying about that. And in fact, Ms. Kopinski was also convicted of obstruction in Douglas 22 FO951. Under Mr. Thone's presence and influence, I can't say direction because I don't know that. Under his influence, she was willing to lie to shield him from drinking and driving where she was the passenger in the vehicle. I think that's a necessary component of looking at this pattern because this isn't just look back 4 months at what happened in Barron County. I think the court should look back further to that Douglas County 2022 case to see there's been further signs of this kind of influence, this negative impact on her life. That under his influence and in his presence, she would be willing to lie to protect his continued behaviors of drinking and driving. I think I want to demonstrate that to the court because it shows there isn't just the single aggravation of what happened in Barron County. There's aggravations, plural, with this longer term, this longer pattern of undesirable behavior is the language we use in sentencing language. This longer pattern of detrimental effect on the victim, in this case, Jennifer Kopinski, not just the physical injury in Barron, but the negative influence we saw in the Douglas case. It contrasts very starkly with the account we get from the victim impact statements, both orally in court today and the ones filed with the court. There is something Mr. Thone mentions in the PSI as though it's a mitigating factor, and I suspect the defense is going to argue it as one too. That is the fact that Mr. Thone has a disease called Huntington's disease. Huntington's disease is a horrific genetic disorder. It causes profoundly negative, degenerative, impactful symptoms that only worsen and worsen until the person dies. It's really terrible. I feel truly sorry for anyone who has it, including Mr. Thone. But in this case, I have to talk about it because it's a double-edged sword. What I mean by that is right off the bat, with the severity of symptoms Mr. Thone describes in the PSI, there's a real question of why is he driving at all? Not in terms of Is he legally allowed to, what could you do? I mean, the question of what should you do? The way he describes how it impacts him in all the myriad ways, the way that it's mentioned that the doctors have questioned it in the past, it certainly doesn't seem safe for Mr. Thone to be driving at all if his condition is as he describes it. And yet he continues to do it. I think that's further exacerbated and becomes an aggravating factor when we consider the fact that the PSI clearly contemplates it's not good to be consuming alcohol if you have Huntington's and you're taking the appropriate medications for Huntington's. That's also a bad idea. It worsens. And that way it's aggravating. The fact that he still does it should be concerning. In the PSI, it seems Mr. Thone is remarkably capable of speaking about the effect of his Huntington's, the symptoms of the Huntington's. He's a very good historian of that. Yet he doesn't seem capable of modifying his life, his behavior, his actions in light of what he clearly knows about the symptoms and the impact of Huntington's on him. His sister's theory, according to the PSI, seemed to be that she believed that he's come to some sort of place in life where rather than this being this drinking and driving behavior, this repetitive behavior that started late in Mr. Thone's life, rather than being a result of a cognitive problem from Huntington's, that it's more of a, pardon my language, like a what the hell attitude where I have this horrible disease, it's going to get worse, I'm going to die, who cares? Why live for tomorrow? Why not live for today? You only live once kind of attitude. Furthermore, when you see the chief complaints that Mr. Thone talks about in the PSI about his Huntington's, he spends a lot of time talking about memory deficits and ability to remember things, about basically anything. He shows real struggle to do any of that in the pre-sentence investigation report. The way he describes in particular the memory effect of his Huntington's in the PSI leads to the obvious conclusion that it seems unlikely that he would be a person who'd be a candidate for believing he will be specifically deterred by impacts of his own conduct, or that rehabilitation will be easy or fast or successful at all. He will have difficulty learning because of these memory deficits he describes that he claims are from the disease. If rehabilitation is unlikely, if it's going to take a much longer period of time with Mr. Thone because of the Huntington's, because of these memory deficits he has, if we can't rely on the idea that, hey, my fiance got an obstruction charge and my fiance nearly died in a rollover in Barron. My fiance actually died in another rollover in Burnett. We can't believe that that is going to have a specific deterrent effect on its own. That's when we have to talk about a longer period of incarceration, a longer term of treatment and confined setting, a longer term of practicing sobriety in a controlled setting rather than in the community. It already failed in Burnett County previously because, again, he was on supervision. I'm sorry, Barron County previously because he was on supervision. The end result of what all I've said is I think there's a great deal of information in the PSI to lead one to the conclusion that Mr. Thone is at a minimum resistant to change. For years, he has been with this woman he's claimed he deeply loves, and he's dragged her down. There's no doubt about it. He's put her in danger. He's brought her into his spiral about his condition with Huntington's. He co-opted her into lying for him in Douglas County. He then, in his own words, got lucky when she didn't die when he rolled an ATV in Barron after drinking. 4 months later, he buys the same model of ATV and rolls it again in Burnett County, and he kills her. It was predictable. It was preventable. In fact, Richard Thone, in fact, did predict it. I think you have to characterize his statements to DOC, mention the PSI about the Barron rollover, about we're lucky to be alive. He did predict it. He did predict that if he did the same behavior in the future, she could die. They might not get lucky. He predicted it and he didn't prevent it. I think Mr. Thone, ultimately, when you look at the history of undesirable behavior among these three cases, you have to conclude that he's a somewhat selfish person with a horrific disease that caused him to abandon really hope for the future, thought for the future, and the people in his life that he loves that might live beyond him in it because of his own thoughts about his Huntington's. And that's terrifying because what reason do we have to believe this won't happen in the future? One of the victim impact statements cautioned the court, we don't want this to happen to another family in the future. This is a situation where he harmed someone close to him, but it could have easily just been another ATV on the road or crossing a highway, a motor vehicle. Because of that, the community has to be protected. The next Jennifer Kopinski has to be protected. Richard Thone has shown nothing to cause anyone of rational thought to believe that he will stop. 7.5 years initial confinement is necessary to incapacitate him, to protect the community, to generally deter people like Mr. Thone, and to have higher odds of specifically deterring him and rehabilitating him in a controlled setting. The 10 years extended supervision will likely be enough to make sure DOC can watch him carefully, possibly with his diagnosis the rest of his life. It is now more predictable than ever that Mr. Thone could pose a serious risk in the community. He is telling you himself in the PSI that his disease makes it unlikely that he is going to remember details that would normally have a specific deterrent effect on a person. He's demonstrated a consistent pattern of undesirable behavior that has not been shaken by terrible consequences to him, to people close to him, even prior to this incident. This sentence is how you prevent it. 5 years, the statutory minimum, would be too little for a case like this where there are aggravating factors. The pattern of undesirable behavior, the influence on the victim, leading to her death, especially when it's repeating that previous dangerous behavior so close in time, only 4 months. We're now at the point where the court, rather than Mr. Thone, is best postured and positioned to prevent what is predictable in the future. I appreciate that Mr. Thone has a terrible disease and he's of older age and his criminal history is not exactly lengthy. Those are factors that are often used in COMPASS and other risk assessment tools to predict recidivism. But I think that when you look at all of the history began later in life with the late life Huntington's exacerbation, it tells a different story, a more nuanced one than that simple statistical fact that older people commit less crimes, people with less convictions commit less crimes. I appreciate he's had somewhat of a consequence already with obviously the person he loved died and died at his hands. That's why I'm not arguing the max in this case. The max could be much, much more, but I cannot countenance arguing the minimum either with the aggravating factors described. Thank you.
All right, thank you, Mr. Schmidt. Argument, Mr. Nelson.
Thank you, Your Honor. I want to address a couple of things that the state had mentioned, specifically with respect to the Douglas County offense from 2022. I actually represented Mr. Thone on that matter, and so I can maybe shed a little bit of light into what was going on there. He was initially charged with an OWI in that case. That was later dismissed due to evidentiary concerns. I don't think it had to do so much with whether the state was going to believe or a jury would have believed Ms. Kopinski was the driver. I don't think that was the issue. The issue that actually came up in that case was with the arresting officer, that sheriff's deputy. I think there had been some misconduct that had been occurring with that particular deputy, and that deputy no longer works for Douglas County anymore. So he had been dismissed, and that was a major. I wish I could take credit for excellent lawyering in that case and getting the case dismissed, but that's not really what happened, Judge. So there were issues there with the credibility of that officer and the ability to call that officer as a witness. And that's what resulted in that. So, yeah, as a result, I mean, Mr. Thone certainly claimed innocence in that case, and Ms. Kopinski backed him up in that regard. And there are some other issues there too that Mr. Thone was upset about that transpired in that case. I really can't say for sure what happened. I mean, I don't know. Nobody knows. So it was never proven one way or the other. But that's what happened in that offense. I think it was mentioned in the PSI. There was an official diagnosis of Huntington's with Mr. Thone in 2020. And then there was a genetic confirmation of that in 2021. But there's also mention in the PSI that I don't know if it was friends or family or what, but that they had noticed what they regarded as symptoms probably for a couple of years before that. So I think realistically, if we're looking at a time frame for Mr. Thone's Huntington's issues, we're probably talking about an onset of around 2018. Looking at his prior history, Your Honor, there was a 2016 first offense OWI. Unfortunately in Wisconsin, it's not uncommon to have a first offense OWI. But if we're talking about really repeated instances like Mr. Schmidt was referencing, realistically, if you look at the timetable, the timeline of those, it really began around 2018 and proceeded kind of pretty consistently from that time on. I'm not an expert in Huntington's disease, but I think it is a little unusual for a person, Mr. Thone at this point is 56 years old, to have gone, 45 years plus of life without seeming to have a problem with alcohol, without seeming to have a problem with driving or any of these issues, any of these recklessness types of issues. And then right around the time that this Huntington's disease emerges, he starts to have this very impulsive type of behavior. And it just suggests to me, and again, like I said, I'm not an expert in Huntington's, but the record, the timeline just suggests to me that there's something that's affecting him cognitively, his impulsive behavior, this reckless behavior. And, part of that too is denial. And just an inability necessarily to recognize, to have the insight to recognize how something may be affecting you. Mr. Schmidt mentioned the rollover in Barron County. Well, that for anybody, any normal person, I think that's certainly an indication that hey, you just dodged a bullet. I mean, that should have been a shot across the bow, so to speak. And Mr. Thone seemed to acknowledge that he was lucky to have made it through that without anybody receiving any significant injuries. But he still sort of wrote it off as well. It was the trail conditions and those kinds of things. And I just think that's an indication of denial. And so, those are things that unfortunately, I think clearly contributed to the current situation that we find ourselves in and the unfortunate loss of Ms. Kopinski's life. But I don't think that he has any basis to deny his problems at this point. And he certainly hasn't shown that in the about 9 months or a year that I've been on the case talking to him about it. Your Honor, this is a difficult case to have. It's always difficult whenever there's a case that involves a loss of life. This is a situation where I wasn't, best friends with Jennifer Kopinski or anything. I don't want to make it seem like that, but I certainly did. There was never a situation, Your Honor, where I dealt with Mr. Thone and didn't deal with Ms. Kopinski. They were together constantly, and Ms. Kopinski, in many ways, was Mr. Thone's biggest defender. And there are many times that Mr. Thone would talk to me about his case or something that was going on. And had a hard time communicating. And Ms. Kapinski would jump in and she would be the one that stuck up for him and advocated for him. I think that he relied on her a lot. And I don't think that there's kind of been a suggestion that, Mr. Thone doesn't care about what's happened or that his feelings for her were not genuine or something. And to me, that's crazy. That's a crazy assertion. I don't think there's any basis to conclude that. I think that they were two peas in a pod. When I had heard about this case and the fact that she had lost her life, it was very sad to hear that. I liked Ms. Kapinski. She was a nice lady. And it's very heartbreaking to hear that this had happened. And for what it's worth, Mr. Thone has never indicated anything other than that he is absolutely devastated by what he's done. And a case like this, the National Highway Traffic Safety Administration used to have these ads on television. I mean, the court might have seen these, but they're like a PSA ad, and it's to try and convince people not to drink and drive. And to sum up the substance of the ad, it's a person leaving a bar and they're going to get into a car and drive. And the suggestion is that they've been drinking. And then sort of behind the bushes, the state trooper peeks his head out. And it's like, you think that you're going to get away with drinking and driving, but, we're out there and we're going to catch you. And, I know that they probably spent a lot of money on those ads. And they had probably smart people that were working to make those messages. But I always thought that those were really dumb ads, frankly. And I thought that they really were a missed opportunity. Because I never thought that the reason that you don't drink and drive is because you might get caught. I never thought that that was the real reason. That makes it into almost like a game, It's like if I make it home, do I get extra points if it was a longer drive or something like this? That's sort of a stupid way to think about this. The real reason that you don't drink and drive is this case. This is the real reason you don't drink and drive, because Mr. Thone, who doesn't remember anything, he was also injured in this accident, and I think was found more or less comatose or moderately unresponsive when the EMS workers came to the scene, but had received a good knock in the head. But at any rate, Mr. Thone more or less came to or woke up in the hospital and had to be told that all of this happened, and has had to process that now he's responsible for this. And this is something that he wakes up every day and has to think about the loss of Ms. Kapinski and his relationship with her and how he misses her, and the companionship that she provided for him and their connection to one another. I don't think that Mr. Thone had many family ties. It seemed like he was kind of estranged from his family. I know they talked to his sister, who kind of seemed to indicate she didn't have much to do with him. Sounded like he didn't have a whole lot to do with his son, who lives in Washington, D.C. They might have been somewhat estranged. Maybe they were starting to make inroads there, but didn't have a lot of connections to them. I think Mr. Thone really relied on Jennifer Kapinski. I think they were kind of each other's world to a certain degree. This was the only person that he had in his world that prevented him from being completely alone. And her loss has been absolutely devastating to him, and it's affected him in a profound way. Everybody feels the same way about this case, including Mr. Thone. He's completely disgusted, upset, sad, despondent, angry at himself. I have yet to have a meeting over the course of representing him on this matter where he has not sobbed at some point during the discussion, the conference. He's been emotional consistently with respect to this, and this has been something that's greatly affected him. In terms of him taking ownership or accountability for this, Mr. Schmidt and I had certainly talked about the particular offense that Mr. Thone was pleading to. As Mr. Schmidt indicates, this is a prison case. I think statutorily it's a prison case. I don't think the court has any leeway there. I don't think the court can suspend a sentence. I think the offense itself mandates a bifurcated sentence. He's got to have a bifurcated sentence. So this was discussed. This is absolutely discussed. And furthermore, it's not really a hard mandatory 5-year minimum. There's grounds there for the court could dip below that, but realistically speaking, it's a 5-year minimum for all intents and purposes. And Mr. Thone accepted that. So by virtue of his plea. So I don't think that Mr. Thone is trying to avoid accountability here. I don't think there's any reason to suggest or to imply that his grief or his feelings of accountability for this are not legitimate. I think clearly it's the case, Your Honor, that Mr. Thone has been affected by this greatly and will continue to be affected by this for the rest of his days. I don't think he'll ever forgive himself, Judge. In looking at this, Your Honor, I've represented people for about 20 years now, and it's been a couple of thousand cases that I've had over those years. And when thinking about sentencing, just philosophically about sentencing, I think one of the interests that you kind of have is you want the feeling that in some way that you've reached the defendant a little bit. I've heard a statistic a long time ago. I think it's probably accurate that if you took away the offenders that have committed 3 or more offenses, you would reduce the overall crime rate by something like 80%. So in other words, 4/5 of the crime is committed by people that are multiple offenders. And you've got a tiny nucleus of people that are really causing most of the criminality that exists in the country. And there's a lot of interest in trying to find ways to stop that recidivism and to make some kind of cognitive change with those people. And some of it is the idea of deterrence with lengthier prison sentences, that maybe this would be a deterrent that would help people to modify their behavior to not commit offenses in the future. And that's a legitimate philosophical motive for looking at a lengthier sentence for someone. As I indicated, Your Honor, I think that this is something that has been a complete shock to Mr. Thone. I used the word denial before. I think that he was in denial. I think that he's beyond that now. I think that he's left that behind. I think he's had to, the circumstances. He talks a lot about Jennifer. When I talk to him, he talks about missing her. He talks about thinking about her, dreaming about her, speaking to her in his dreams, those kinds of things. This has been something that has been weighing on him greatly during the entire case. And I don't think he needs to be reached any longer. I think, it is a prison case. There's a loss of life here, unforgivable loss of life. I want to echo Mr. Schmidt. Mr. Thone's issues with Huntington's disease, he's on medication. He should never be drinking again. He should not have been drinking. And nor should he be driving, I don't think. I think there's enough, what I've read about Huntington's disease, there's enough there about how it affects your motor skills and things. I don't think there's any way that he should have a license. And he shouldn't be operating. He never should have been. He probably should have been, he should have hung those things up maybe in 2022, so that was, I think that's clear at this point. And I doubt that he's ever going to be able to drive again. He may get his hands on liquor at some point. I hope not. But he certainly has said, I'll never drink again. I know he's been doing AA in the jail. There's not a whole lot of programming there. He's not eligible. We talked about, Your Honor, he's not eligible for ERP due to the 940 nature of these offenses. He couldn't earn early release, but I think that he would probably benefit. It would probably be important for him during his period of incarceration that he would make use of the substance abuse program regardless. So I would certainly ask that the court would deem him eligible at least to attend those sessions, even if it doesn't result in a modification of his sentence at all. I think that that would be quite important for him to do. So, I think a 5 years is the minimum or thereabouts. I think that that's a sufficient amount of time, does not diminish the seriousness of the offense. And I think a further sentence, a longer sentence, you start thinking 6, 7, 8, 9 years. I think the concern that I have, Your Honor, relates to the progression of his Huntington's disease. I think since 2022, when I met him, or 2023, when I met him, I think he's probably a little bit worse, Your Honor, over that time. I think the last year obviously has been pretty stressful. Obviously, so I think that has not been helpful to him. I did look up some stuff about Huntington's disease from the Cleveland Clinic website, which I would read for the court. I think it's important for the court to consider this. This is from the Cleveland Clinic, which I guess is a research hospital. This is from their website. How does Huntington's disease progress? Huntington's disease is a progressive condition. This means it slowly gets worse over time. The way the condition progresses varies for each person, but may include, at the early stage, symptoms are mild. You might feel moody or clumsy and struggle with complex thinking. You may also have small, uncontrollable movements, but typically you can continue your everyday activities. I think that this probably describes Mr. Thone's Huntington's disease, at least up to the recent period. However, in the middle stages, according to Cleveland Clinic, physical and mental changes make working, driving, and household chores very difficult. You may have trouble swallowing, which can make speaking and eating meals challenging, but not impossible. Your balance may be off, increasing your risk of falling. You can still manage your personal care like bathing and getting dressed. And I wonder if he hasn't slipped into that middle stage at this point. I think just some additional difficulties, Your Honor, in understanding Mr. Thone. His gait is not exactly the same as it used to be. And I think he may be entering into that middle stage. And then at the end stage, according to Cleveland Clinic, completing daily tasks is hard to do on your own. Most people aren't able to get out of bed without help. You'll need around-the-clock care during this stage, especially to eat, bathe, and monitor your health and well-being. So, I'm a little concerned if you're talking about a lengthy prison sentence, that he's probably beginning to slip into the middle stage, and how much longer would it be until he's in that end stage situation where he's needing help even to get out of bed. Also from the Cleveland Clinic, what is the life expectancy for Huntington's disease? The average lifespan after Huntington's disease diagnosis is 10 to 30 years. So there's a bit of a range there, Your Honor. Obviously, there's a big difference between 10 years and 30 years. But if we're thinking that symptoms probably cropped up around 2018, 10 years is 2028. And so that's he's in that range where could reasonably be expected to have potentially life-threatening or high impact on his quality of life progression of the illness. So I think the court obviously should do what it feels is necessary and appropriate in this case, given the statutory factors. I think that it probably is not in the court's, in the interest of the system that Mr. Thone be, at Stanley or wherever he ends up, needing round-the-clock care. I don't think that that's appropriate. So I think that mitigates towards a sentence closer to 5 years than closer to either the 7.5 or the 9 or 10 that's recommended. So our recommendation, Your Honor, we don't duck the idea that this is a prison case. It's obviously a prison case. We would suggest a period of initial confinement of 3 to 5 years range, somewhere in there, with extended supervision of 5 years. And again, as I said, I think he could make use of that substance abuse program while he's in custody. So I think that would help him.
Thank you, Mr. Nelson. Mr. Thone, I'm now going to turn to you to see if you wish to make a statement in court here today. It can be about anything involving the case, you, the situation. You don't have to make any statement. It's just your opportunity if you wish to do so.
I'm sorry for everything that's happened, and I'm ready to deal with the punishment that I'm gonna get for it. That's it.
Thank you, Mr. Thone. Mr. Thone, you have been in court before and you've had a couple convictions that are on your record, but you don't have a very extensive criminal history. You have the disorderly conduct and the resisting or obstructing an officer, that Douglas County case. You have an OWI second from Eau Claire County in 18 CT 94. You have Trumpereau County with your OWI first. You have that Barron County matter that was extremely similar to this case, except for the fact that you both were only injured and no one died. So you don't have a very extensive criminal history or knowledge of what occurs in a sentencing. So I will go over them with you so you can understand. If I'm going too fast, please let your attorney know so I can slow down, so that I know that you understand everything, okay?
I didn't understand what you said at the beginning of all that.
Okay, thank you. So when a court sentences an individual, I must first look at the nature and the gravity of the offense. How serious is this matter? Then I have to look at your character, your past criminal record, needs for rehabilitation, those types of things, take into account your Huntington's disease, as well as your education, all factors related to you. The third thing that a court must look at is needing to protect the public. And that means protecting the victim and the victim's family, as well as protecting the community as a whole. And when the court looks at protecting the community, there are other factors that come into play. The court has to look at, again, do you have rehabilitative needs? Are there needs that you have that services can be provided, such as treatment, those types of things, and we can see you rehabilitate. We can see you change your life, change your conduct. The court has to look at undesirable behavior patterns. Has this happened before? Do you have a history of doing things similar? The court looks at your culpability. How much of this is your fault? I have to look at, again, deterrence, as Mr. Schmidt pointed out in his argument, deterrence. specific deterrence, some type of punishment and sentence that would deter you from continuing in this type of behavior and actions, and otherwise general deterrence, a sentence that would deter others from engaging in this type of conduct, or for taking a second or third thought, do I want to do this? What could the ramifications be? What could the outcome be? Because as Mr. Nelson stated in his argument, this is very serious. This is an OWI offense that resulted in a death. And so it's very serious. And OWIs are not a game. It's not how can I get home? Can I get home the quickest? Do I get more points if it's a longer drive and I make it home safe, even though I know I'm intoxicated? It's not a game. It's life and death. And here we had a death. So again, it's very serious. I've heard the arguments of both of the attorneys. I've heard your statement. I've heard 3 victim impacts statements and how this loss has completely traumatized this family. And I don't necessarily want to say destroyed the family. Hopefully it has been something to bring the family closer together, but it is a loss that is immeasurable. They will never get to see Jennifer again. The grandkids will never get to have that close relationship with her and have grandma come to their concerts at school or their sports and activities, those types of things. It's a tremendous loss. You admitted here, and I believe it's from the very beginning, what you have done, that you have caused the death of Jennifer. You were driving while under the influence and in fact intoxicated. And you've done it before. So it's very serious because you do have that 25 years of initial confinement and 15 years of extended supervision hanging over your head, where the court could say, based upon the facts of this case and the facts of your history and the facts that have been presented to the court, that this is so serious that you could spend essentially the rest of your life in jail, in prison, the rest of your life behind bars. Or the court would have to determine whether or not this is something that doesn't quite reach that level, but maybe something in between. You did accept responsibility by pleading guilty. You saved the family from even more trauma and more pain of going through a trial. That's a positive thing. I say this a lot, and I really wish that it could happen, that if I had a magic wand, I would change everything that happened and bring Jennifer back and make everything good as gold. I'm sure you have the very same wish. Unfortunately, this is reality and we can't do that. We are here where we are here today, all because of what happened on, I believe it was August 17th, 2024. This is, I don't think there's anything worse than a loss of life, and especially a loss of life that it was predictable, and it was definitely 100% preventable. You have the history of drinking alcohol to an intoxicated level, and operating a motor vehicle. This would be the third, at least third conviction related to that. You should have known better. You should have known that, especially considering 4 months before, and I believe that was April 27th, 2024, 4 months prior to this accident, this unnecessary accident to occur, you did the very same thing, but in a different county. You drank to excess, you drank to intoxication, you drove a UTV, you rolled and crashed that UTV, both you and Jennifer, Ms. Kopinski, were hurt and injured, and you were charged with charges that, for whatever reason, was not a crime, simply a forfeiture, a ticket. But it was the same actions, the same conduct, the same behavior, the same thinking as we have in this matter. The only difference is death. Predictable and preventable. Mr. Schmidt said it a lot in his argument and in his statement to the court, because this is 100% that, predictable, preventable. Especially considering the diagnosis in 2020 with your doctor with the Huntington's disease. I'm not positive. I was not in the doctor's office with you. I didn't receive your medical documentation and recommendations from your doctor, but I've had multiple people in front of the court with Huntington's disease before. So I know a bit about it, and I've learned a bit more now about it from your attorney's argument, which was very insightful. But I'm going to guess, and I'm pretty sure I'm right, that when you were diagnosed with and confirmed that you have Huntington's disease, your doctor told you, do not drink alcohol. Probably not simply, you shouldn't drink alcohol because X, Y, and Z. I'm going to guess your doctor said, you cannot drink alcohol, because I know alcohol speeds up Huntington's disease, the use of alcohol. And especially on the medications that you need to take with it, it increases the effect of alcohol, even though your body, your brain doesn't necessarily feel that effect. There's no doubt in my mind you loved Jennifer. There's no doubt in my mind, but so did everybody here. You have to live with the loss of Jennifer. The family has to live with the loss of Jennifer, but they're completely different. Your actions caused the loss, and it could have been prevented. I agree with the statement and argument that was made by Mr. Schmidt about this double-edged sword. In reviewing the information in front of the court and by the attorneys for this case, and your statements made, your symptoms are extremely severe. You should not have been driving or contemplating driving at all, unless it's an emergency, and definitely not if you were under the influence. And with the who cares attitude, we only live once attitude, YOLO, it may be okay for you to have that attitude. It may be okay for you to put your life at risk, but you put so many people's lives at risk that day. And every other day you drove intoxicated, whether in a vehicle, whether a UTV, whether an ATV, you put a lot of lives at risk. And a who cares attitude and we only live once attitude killed Jennifer. And unless you can change that attitude and live to the fullest every day, even with your diagnoses, you're going to continue to put people at risk. You are continuing to be a safety concern for the community. Because just in the short few years of your relationship with Jennifer, you continuously put her in danger so many times. And based upon the facts and the undesirable behavior pattern of knowing these things, yet continuously doing the things that you know you should not do, driving while under the influence and ingesting alcohol. You put a lot of lives at risk. And there's no reason to believe that you won't do this again unless you make some significant changes. And in a case like this, as your attorney stated on the record, that there is a mandatory minimum of 5 years of incarceration, unless the court finds a compelling reason and states it on the record that it should be less than 5 years. Although I understand you have Huntington's disease, although I understand that it's an extremely serious condition and disorder, and that you're going to have a punishment. And even though I now understand a little bit more about Huntington's disease and that you are in the middle stage and maybe in the end stage soon, and that could require continuous care and unable to get out of bed and an early death, I was aware of that possibility. I cannot find Huntington's disease and your position and where you are is a compelling reason to go below the mandatory 5-year minimum. There needs to be deterrence, not only to deter you from engaging in this conduct and to actually compel you to make changes in your life, but the court needs to deter others from doing so as well. I don't know how many deaths we've had in the last couple of years, but it's a lot. It's been a lot. For a small little county, it's been a lot. I love UTVs. I love going on the trails. And yes, sometimes it's nice to stop and have a drink or two. But they are all around us now, all around us, on every trail, in every place. And it is not a party barge. It is not a party on wheels. And perhaps the legislature will look at harsher penalties for intoxicated operation while on a UTV. Because again, things can be prevented. Things can be prevented. The community needs to be protected, and I need to ensure that they will be protected for a significant amount of time, and to have you be given the opportunity to make some changes in your life. With regards to this sentence, count 1, maximum possible penalty 25 in, 15 out. The court is going to sentence you I have 3 different conflicting, they all are different recommendations. 5 years in from defense, 7.5 from the state, 9 to 10 from the DOC. I don't prejudge. I don't I may have an idea of what I would sentence at the time of reading the PSI, but I don't have something stuck in my head. And I don't predetermine my sentence because it's so very important to hear from the state and hear from the defense and hear from the defendant. But based on the recommendations and hearing it again and hearing the arguments today and now rereading and reviewing the PSI, I believe that 10 years of initial confinement with 10 years of extended supervision is necessary. Anything less would unduly depreciate the seriousness of the offense. We have a death, a human life that cannot be replaced, that cannot be brought back. It's a death. Granted, it was not a homicide with a gun or a knife or your hands. It was still a homicide. And it could have been prevented. And because of the mandatory minimum of 5 years, I do find that that is the bare minimum that the court must start with. The fact that this has been occurring multiple times over the period of time that you were with Jennifer and you put her at risk so many times, her life at risk so many times, which ultimately the Russian roulette game was lost this time. And because of this loss and this undesirable behavior pattern, and I can't believe that it only happened this time in Burnett and that one time in Barron. My gut's telling me there are more times and more times that you were driving that UTV while intoxicated with Jennifer. That's why the court is sentencing you to 10 years of the initial confinement and 10 years of extended supervision. $518 in fines and fees. Be paid in payments as determined by the Department of Corrections. Any restitution? No restitution is requested. So the court costs are to be collected as a percentage determined by the Department of Corrections to be reasonable within the state prison as a condition of your extended supervision. Court is ordering your DNA. You can, the jail will make sure that they get your DNA. In this type of case, I do not believe that you would be able to have it expunged from the system. The court is going to make you eligible for the substance abuse program. I am not going to make you eligible until you have a year and a half left on your sentence. That'll be enough time to complete the program if you wish to, and to learn what you need to learn. You are not eligible for the challenge incarceration program. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your court costs and fees, the court will not only enter a civil judgment against you because you're always going to owe it, but I will issue a warrant and you can sit an additional 6 months in jail. You're remanded immediately to the control of the Department of Corrections. No use of or possession of a firearm for life, no voting in any election until your civil rights are restored. Again, 20 days to appeal. Mr. Schmidt, what am I missing?
Just that Wisconsin statute 973-01 sub 3G prohibits the court from finding Mr. Thone ever eligible for SAP or ERP on this.
Thank you. I thought that that was the case, but I wanted to ensure that he had
I
some
should emphasize-
incentive to do it.
For the confinement portion, the court could find it for the ES.
Thank you. Then what I'm going to do is I will strike the year and a half because he has to serve the entire amount of the sentence and he could be eligible for it on extended supervision. While on extended supervision, no use or possession of any illegal drugs, substances, or paraphernalia. Absolute sobriety, absolutely zero alcohol. No bars, taverns, liquor stores, or any place that has the primary purpose for the sale or the service of alcohol. No casinos. Regular drug testing, regular alcohol testing, AODA assessment and follow through, mental health evaluation and assessment and follow through. What else am I missing, Mr. Smith?
Nothing for me.
Mr. Nelson, what else am I missing?
As far as I'm aware, I think the court's addressed everything it needs to address.
All right, thank you.
Is there any jail credit?
Oh, yes, what is the jail credit?
I didn't get that.
I meant to calculate that and I didn't. I'm sorry.
All right, we do have our lieutenant from our jail who is present here today. I know it is not easy and simple, Lieutenant, to make those calculations, but if you can do so and have it sent to my assistant and I'll put it in the file, it can be a week.
Should have it today.
Excellent, thank you. So we will wait until I receive the jail credit before I enter the judgment of conviction. And then, Mr. Thone, if you object to that jail credit after seeing the judgment of conviction and or the information by the lieutenant that will be placed in the file, you have 7 days to object. Anything else, Mr. Nelson?
No, thank you.
All right. Thank you. Then we are adjourned.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.